Thank you. Testing 1, 2. Okay, sounds good. Can you hear me?
Yes.
Wow. Well, what a blessing it is to be invited to speak here again. It's so neat to see people just worshiping and loving the Lord, and I love speaking at churches, so I'm very, very excited to be here. I am going to tell you a little bit about our company and what we do a little later. I'm going to do a commercial, kind of do that. We have brochures that some have been passed out. I have an assistant, Wayne, who's going to help also when we get to that part. But I first want to talk to you a little bit about what we're going to discuss this evening. We're going to talk about the subject of estate planning, and that is planning for something we know is going to happen, right? We don't get out of here alive. We may be raptured, but we're going to leave our stuff behind, aren't we? And those things, if we die of natural causes or the Lord takes us in one way, are going to go to somebody else. But how they go depends on what we do planning for that departure. And there are things, we live in a land of laws and contracts and deeds. So the things we need to do need to be legal and they need to be done right. So we're going to talk about what are your options. What if I die with no plan at all? What happens? What if I die with just a last will and testament versus a revocable living trust? And we're going to talk about different scenarios. But I want to also tell you this, that what I'm talking about has some real practical, real world relevance, but it certainly.
Do you want me to move this pulpit out of your way?
No, I'm fine. I can see everybody as long as everybody can see me. Is that okay?
Yes.
All right. But thank you, Pastor. Appreciate that. The Bible talks about us as stewards, right? The assets the Lord has given us, He has given them to us, right? To take care of ourselves, to take care of our family, to continue God's kingdom, to do His work. And to also bless our children. It says in Proverbs, a good man leaves an inheritance to his children and his children's children. So it is not a bad thing to accumulate wealth in this world and then give it to heirs, but how we do that matters. And so we're going to talk about that. We're going to talk about the best way to keep the family from fighting and keep the money within the church, if we can, and within our families. So we'll talk about that. Well, let me start off by talking about what happens if we don't do anything. We have no plan in place. I know that's some of you. I'm not asking for hands, but some of you have nothing in writing, no will, no trust, no plan, except, take your vitamins, eat well, look both ways when you cross the street. That has been your estate plan so far. Hope not to die, okay? But some of you need to put a plan in place. Well, we all need to put a plan in place. So what are the options? Well, if you do nothing at all, and every year you say, I really need to do something, I really need to do something. And the next year you say, I really need to do something, but you keep doing this kick it down the road thing, and you die like that with no plan. That is called dying intestate. When you die intestate, there is no plan. The government makes a plan for you. The Commonwealth of Virginia will create a will for your family. This new will go through a legal process called probate, where the assets will be tied up in the court, where the families have the opportunity to come and fight over the things you left. Not what you want, but you didn't put a plan in place, so you get the government plan. There's two things I'm pretty sure you don't want. You do not want to send your families to court when you die, and you do not want the government writing your will. You see, the government doesn't know any of the family details. They don't know that Susie already got her inheritance. Jimmy hasn't talked to Dad in 10 years. Barbara never paid back the loans. But you know who does know all of that? The family knows. And when they get to the court, it often sounds like this. Your Honor, this thing you guys came up with, not even close. She shouldn't get, he already got, Mom wanted me to have, and guess what they do? They fight. And do you know who wins that fight besides the lawyers? The lawyers always win. The government, and whoever hires the better lawyer, so Jimmy, the more clever one, hires a good lawyer, and when they go to fight, he's the only one ready, and everybody's shocked that he got more of the estate because he had a good lawyer. Now that's sad, but here's the saddest part of all that. The family often doesn't talk to each other for decades because of what Susie did or what Johnny tried to do. So the do nothing plan, I will admit, is the cheapest plan today. But it's not the one you want. It costs you nothing to do nothing, but it costs your family the most. So don't go out with no plan, please. So let's say you're convinced you'd rather do something, you think that's good stewardship. I will put a plan in place. What are my options? Here's an option. You can do something called a last will and testament. You've heard of that, right? Some of you have a will. Let me remind you what a will is. It basically is a set of instructions that says, when I die, I want these things to go to these people. But what you need to also know is a will has to go through probate. Whether you write it or the government writes it, wills get probated. They go through the court process. Wills can be contested by anybody. Oh, Dad was mad when he wrote that. Oh, Mom really meant for me to. They can say anything and you're not there to defend yourself. Wills get contested. Wills do not help us at all if we become incapacitated, because a will does not go into effect until you are dead. So though a will is an option, it's a very limited option. It doesn't do all that we need to have done. There is a great option available to all of us called the Revocable Living Trust. Now, the Living Trust allows us to transfer our assets to our heirs when we die, but it does so without courts, without probate, without delay, and most of the time, if we do this right, folks, without fighting. Because this is a binding document. It's not contestable like a will. And so they get what we say they get, in the sense, if they can fight, they might. If they can't fight, they can't. So this is much better than just letting them work it out in court. So it is a better option. The trust not only takes care of distribution when we're gone, avoiding the courts and the fighting, the trust also takes care of us while we're living, because in your trust are what we call incapacity documents. What if I'm not dead but mentally impaired? Alzheimer's, dementia, a massive stroke, a car accident renders me not the same person I used to be up here. Who's going to pay my bills? Who's going to manage my estate? I can't sell a house if I'm mentally impaired. I can't pay my bills. So someone has to do this for us. Who do you pick? Well, you get to pick who you choose. And the person you choose within the trust is called your power of attorney. Now, I'm married, so my wife is my primary power of attorney over financial matters. She's also the power of attorney for my health decisions. I trust her to do the right thing if I'm unconscious, unable to speak. So as a married couple, usually your first choice is your spouse, your mate. But what if she dies in the accident that I become impaired in? I just lost my wife and my power of attorney. So when you name a choice, always name a backup and name a backup. Try to get 2 to 3 layers deep. My first choice, my second choice, and my third choice. Are you guys with me here? It's important to think beyond what the first thing, because that may not work. So think of a second and a third. As I said, there is a power of attorney for financial. Who's going to pay the bills, sell the house? Who would make the medical decisions if I can't make those? So that's the health care or the medical power of attorney. So there's 2 different powers of attorney. And then there's also in your trust something called the Advanced Medical Directive, sometimes called a living will. And these are our end-of-life choices. You're on a feeding tube, a respirator, you're terminal. How long do you want to be kept on the machines? And when do you want to be taken off? And I will tell you, everybody has an opinion. But when you're in that condition, your opinion doesn't mean anything. What matters is what you have in writing, folks. You have to do it in writing. Some of you might remember Terry Schiavo, the girl in Florida, where for 15 years in court, they argued over a feeding tube in court. Why? She didn't have her wishes in writing, folks. So your wishes are nice, but they don't mean anything till we codify them, have them witnessed and notarized. So it's important that we don't just have ideas, but we put them in legal documents. Does that make sense? Now, a lot of people have heard that a trust avoids probate, which is true, but not everybody's sure they even know what probate is, so I know I'm not supposed to want that, but what is it? Let me start by telling you what it is. Probate is a judicial process. When someone dies, the state, through the courts, they have to verify and validate any wills or instructions that you've left to see if these things are current, relevant, up to date. They have to settle family disputes. They have to pay the debts of the deceased. And when all of that is over, eventually, assets get distributed to the heirs at the end of probate. Now, folks, there are 2 major misunderstandings about probate. Here's the first one. Some people think, now they're wrong, but they think that a will gets you out of probate. That's not true. Wills are probated. They go before the court. And in many cases, the judge who looks at your will has to decide if he's going to follow your instructions or not. Now, you might say, well, why wouldn't the court follow my will? I took the time to write it. It's notarized. I mean, why wouldn't he? Here's why, folks. Think about this. A will is what you wanted when you wrote it. that's not always what you want 10 years later. I had a guy come to my meeting once. He said, Daniel, I have a will. I wrote it 15 years ago. The will gives everything to my wife, Kathy. He said, the only problem with that is I've been married to Susan for 7 years. He said, Kathy was my wife 15 years ago. She's now my ex-wife. And I said, yeah, and according to this, the beneficiary of your estate. Oops. Had a lady the other day said, you just reminded me my ex-spouse is still on my 401k because she hadn't removed him yet. And people have these out-of-date wishes, and if you don't clean it up, the state will clean it up after you're gone. You don't want that. The second misunderstanding about this probate that we don't want is that some people think they don't own enough. Well, I got a house, but it's not that nice. I got some money in the bank. I'm not wealthy. You do not need to be wealthy to trigger this thing called probate. Now, every state, it's different in West Virginia, Maryland, North Carolina. Every state has a dollar amount of what triggers a probate if you die in that state. The state kind of says this: if you own less than this, your estate skips probate. But if you own more than this amount, it triggers a probate. Well, here in the Commonwealth of Virginia, folks, that dollar amount is $15,000. Did you hear what I said? That's a 1 with a 5 and a comma and 3 zeros. There are cars in the parking lot worth more than $15,000. Most of you have a estate larger than 15. It's quite a low threshold. Now, some people have confused what triggers probate with what triggers something else they've heard. People have said over the years to me, Daniel, didn't it used to be $650,000, then it went to $675,000, and then it went to like $1 million? I said, no, that's never what triggered probate, but that used to be what triggered federal estate tax. Now, federal estate tax is where the government says, hey, you died with too much money, but we're going to help you out over here, and we're going to take some. That's called a death tax. To trigger the federal estate tax today, folks, you have to have over $5 million. And I'm just assuming most of you are just under that. You may not have enough to trigger federal estate tax, but I'm sure most everybody here has enough to trigger probate. 15,000? Yeah, most of us live between 5 million and 15,000. Okay, so a will doesn't get you out of probate, and you certainly don't need to be wealthy to trigger this probate. So what's so bad about probate? Well, probate's different for every family and every county. It's a little different. But there are 3 things that are constant that people don't like about probate. It is lengthy, it is expensive, and it is public. I've done meetings like this, sometimes 3 and 4 a day. This is my 3rd meeting today for 13 years. All over the state of Virginia and all over in different states. But I'll tell you what people tell me. Yeah. It was a year to a year and a half in probate. That's how long it takes to get through probate. It isn't quick. I talked to someone this afternoon who's in 4th year of probate, and it's not over yet. So probate isn't quick. But even if it was on the short end, 12 months, assets are frozen, can't be gotten to, money can't be gotten to, houses can't be sold. It's in probate court. So probate's not quick. Here's the second problem. It is expensive. There are the attorney's fees, court fees, filing fees, assessor's fees. Sometimes accountants get involved. There's Virginia probate tax and sometimes county probate tax. And where does all that money come from? The estate. The money you were going to give your church or your children is now going to attorneys, courts, and judges. And they say if nobody fights or argues, the national average of what is lost when an estate goes through probate is 8 to 10% of the gross market value. I will tell you in Virginia, it is a little lower. It's 6 to 8% of the gross. But I didn't say of your equity. I said of the gross. What market? That means selling price. So let's say your house would sell for $199,000. Some of your houses are worth twice that, but let's just say it was $200,000. Everything else you had was another $100,000, investments and antiques and things. So your total estate was $300,000. Well, 8% of that is $24,000 that your children won't see. And that, folks, I have to tell you, is if they don't fight. Because if Susie hires a lawyer because Jimmy hired a lawyer and they go at it, I've had people say, well, I was in probate court fighting with the family. You know, Mom would be embarrassed if she heard what you just said, and they're going at it. And the judge finally said, you know what you guys all need to do? Go in the hallway and figure this out, because right now you're giving all your mom's money to these lawyers. And you may have not noticed they're in no hurry to get out of here. Because the longer you're in here, the more they get and the less you inherit. Because court is not a friendly place, it's adversarial. When lawyers talk, they call it argument. First argument, closing arguments. It's not good. And sadly, it's not your children sometimes that fight. It's the ones they married. your daughter-in-law says to your son, well, how come she's getting that? And the next thing your son goes, yeah, why is she getting that? And here you go down that path, folks. And you know what? It's sad, but it's money sitting on a table and people want it. And you know what? We can't control what they want, but we can control what they get if we do the right thing. We can set some things in motion to keep them from fighting and keep them out of the probate process. So probate is not quick, it's lengthy, it is also expensive. Now, you know how much you get to control in the probate process? None of it, you're gone. But you know how much your kids can control? Very little. See, a guy told me this story. He said, my father-in-law died with a will. We spent 18 months in probate. During that year and a half, the value of his stock had dropped $60,000. Bad timing, I guess, right? Imagine if someone died and left you a home in 2009 at the peak of the market, but you didn't get to sell it till 2011, a couple years later, because it was in probate. How much equity might you have lost in those years when things were dipping? And you know what you don't get to tell the judge when you're in probate? Hey, can we move things along? I'm losing money over here. You know what the judge will say? I'll let you know when we're done. You're not in control of any of that. You're just a passenger in the ship and he's driving it. It's sad. Now, the third problem with probate is there's no privacy. Did you guys know that when you die with a will, your will becomes a public document and anybody can read your wishes? Nosy neighbors, ex-spouses, disgruntled family members, but not just read your will, anybody can contest your wishes. That's right. Now, not all wills are contested, but usually it's family. You know, why is Jimmy getting the boat? Grandpa promised me the boat. Well, at the end, Grandpa promised everybody the boat, if you know what I'm talking about. The wheels weren't spinning like they used to, but people get their heart set on things, you know? It's not good, but they do. And they go, well, that ain't right, and why is he? And, you know, and they argue. And they have a place to argue. It's called court, which is sad because you open that door for them. But it's, you know how public your will is? I could go to court tomorrow and read wills. Oh, look, he left some money for the VFW. That's where I met him, maybe. Public information, it's kind of sad. Yeah, your will becomes a public document. Anybody can contest your wishes. Some of you in this room, some of you will not remember this man, but some of you, more my generation, might remember a man named Charles Kuralt. He had a show years ago, On the Road with Charles Kuralt. Well, he died about 15 years ago. When he died, we discovered he wasn't alone on the road, apparently. Some of you remember the story. Woman lays claim to the Kuralt property. Here's what happened. Charles dies with a will. His will says his wife and children are to get the entire estate. But as the will's going through probate, a woman showed up and said, Your Honor, Charles and I had a long-term affair, and I can prove it. So out come the love letters and the handwritten notes and the receipts. We call that evidence. Today it would be text messages and emails, right? I guess you could ask Tiger Woods or General Petraeus, right? So what happened? The court listened to her and looked at the evidence she presented, and the court awarded her the ranch in Montana, all the buildings on it, and other property. That's right. Now, why would the court do that? She's not even mentioned in his will. Of course, that would have been awkward. Honey, you get this, and the lady I'm having an affair with gets that. So she's not mentioned at all, but the court, you have to understand, has no obligation to follow your will. It doesn't. Your will is a piece of evidence brought before a court that hopefully reflects the wishes of the deceased when they died. We know it reflected your wishes at some point because you wrote it that way, but things change. Imagine this, I'm the judge and I have to decide what to do with this gentleman's estate. By the way, I don't know the deceased and I don't know his family, but I do have a set of instructions. And here's the decision I have to make. Well, let's see. Do I follow this 20-year-old set of instructions, or do I listen to what John said Dad promised, or what Kathy said Dad wanted? And what she wants and what he says and what this says are three different things. So who do I believe? And guess who I can't ask? The person whose estate. That's the problem. For the courts don't know your mind. Here's the good news. You don't have to have a probate at all. When you get a revocable living trust, there will be no probate waiting for the family. Instead of your assets being tied up in the court for a year or two, within days of your passing, they are available for distribution. I mean, while people are in town for the funeral, the executor can go to the bank, get some money, and start distribution and put the house on the market. We are talking days, not years. Instead of your family losing tens of thousands of your hard-earned dollars going to courts and to judges and attorneys, whatever you spent on a trust is going to be a lot less expensive. Now, I am not going to shock you when I tell you this, but did you guys know that attorneys don't do this for free? Now, you can go out and find a lawyer and sit in a leather chair, and tell him what you want and have a trust made. And most of what I hear people say, well, we spent, and I hear a number between $2,500 and $3,500. We do this for about half of that, and part of the reason is groups. I talked to all of you at once, already done 2 groups today. And it's volume. You know that it's an economic principle. If you do the same thing at the same place, you can bring prices down. It's cheaper to buy something at a Costco than a small little market way out in the middle of the sticks, because more people go there to do the same thing. Because more people work with our attorneys in our group, you get a better price. The other thing that's so great about a trust, folks, it is a private document. Now, a will, when you die, becomes public. A trust remains private. I mentioned I could go to the courthouse and read wills. Imagine I read this. Oh, look at this. A 19-year-old's going to inherit $30,000 from his grandpa. So I mail that 19-year-old something in the mail. Hey, would you like to be your own boss? For $20,000 and my proven method, you will be the vending machine king of the area, And he goes, wow. And all you have to do is pick up the money on Fridays. Folks, not only do creditors go through these wills, predators do too. And they find the young and weak and the easy. It's sad. But with a trust, the only one that gets to read the details of your living trust are your beneficiaries. Not nieces, not nephews, not neighbors, just the heirs. And that's one of the many reasons why Susie Orman, Wall Street Journal, Forbes magazine, they're telling you want a trust. Modern Maturity magazine said this a few years ago. If you look forward to going to the dentist or paying taxes, you might like probate. Probate's costly, it's slow, outmoded, a sad state of affairs. Trusts, however, are a valuable estate planning tool. Some of you might remember or are familiar with Susie Orman, seen her on TV, read her books. She just said, regardless of how much you do or do not have, in most cases, a will is not enough. You'll also need a revocable living trust with an incapacity clause. What's that? The powers of attorney, the advance directives. So a real quick recap, the do-nothing plan is the worst. It's the one that lets the government make all of your choices. You left no instruction. A will is better than nothing, but wills do go to probate. They are fought over, they're contested. By all means, the trust is your best option. I want to give you one other. And I want to talk about the dangers of joint tenancy just for a second. Now, most husbands and wives own assets together, am I right? Jointly. When one dies, who owns the asset? The other. And there is no probate when the first spouse dies. But eventually the second spouse dies and there's a probate. What happens if you die together? Probate. So just so we understand the basic rules here, joint tenancy doesn't solve the probate problem, it just postpones it. Are you guys with me so far? Some people think they've come up with this idea, well, now that my spouse is gone and I own the house by myself, I don't want it to go to probate. I've got an idea. I'm going to put my son or daughter on title with me. That way when I die, they take over, it skips probate. And listen, it does. But I want to give you 3 reasons you never want to do it like this. You can, but listen to this. When you put your son or daughter on title, folks, they're not just joint tenants, they are co-owners. And as a co-owner, if they get into a car accident, their dog bites somebody, someone slips on their property, there's a lawsuit, there's a judgment, what can they attach? Anything they own, which is half of your property. Okay, your daughter's on title. She discovers her husband didn't take the vows as serious as she did. She caught him cheating. She throws them out. They divorce, and he gets half of what she owns in a divorce settlement. That means 25% of your equity just left with your ex-son-in-law. Oops. Your son bought his house in 2009 at the peak of the market. Hey, a lot of people did. It was going up in 2007 and 2008. But in hindsight, we know in 2009 it started doing that, right? Housing market. He says, Dad, I'm still upside down $75,000. I don't think it's coming back for me. I'm going to let him have it. And he doesn't pay, and they foreclose. He doesn't have a house, but you do, with a lien on it, because your co-owner stopped paying his bills. Folks, when you commingle assets with your children, their problems become your problems. That's reason 1. Reason 2, distribution. Let's say I have 4 children and I make a deal with my son. Hey, Charlie, we're going to own the house together now that Mom's gone. Now, when I die, I want you to sell the house and share it with your sisters. And he says, all right, Dad, I'll do it. Does he have to? No. No, Charlie got a house and the girls got disappointed. I'll tell you right now, brothers cheat sisters and sisters cheat brothers. Don't even open that door. And somehow they justify it. I guess mom knew I needed the house. No, you're not doing what you were told or what you should have done. But even the third reason, let's say you have an only child. Well, I'm going to put Barbara on. I'm giving everything to her anyways. And you die. Now Barbara owns the house. But watch this. When she goes to sell the house, she has to pay capital gains tax all the way back to your original purchase price. I see some gasps in the crowd. Imagine you bought your house, and I don't know what your homes are worth, but let's say you bought a house 25 years ago and you paid $200,000 and now it's worth $400,000. It's doubled, a $200,000 gain. Does anybody know what 20% of $200,000 is? $40,000 they owe the IRS. But listen, none of that's going to happen when you pass your estate through a trust. When you pass the estate through a trust, your children are not co-owners, they're beneficiaries. As beneficiaries of your estate, there is zero capital gains tax due. Zero. I don't care if you paid $100 and it's worth $600. Nobody pays on the $500 that it gained, because at your death, everything in the trust gets a new, what's called a stepped up tax basis to the current value. No tax to the children. There is no distribution problems with my trust, because if it says 25%, do you know what it is? 25%. It's not negotiable. It's not contestable. It's called a revocable living trust. It just means while we're living, we can change it. We can revoke our previous instructions. But when we're not living, it becomes irrevocable. And you know what irrevocable means? That's it. That's what you get. So I always tell people, if you don't like what your parents wrote inside the trust, you do have the right to be disappointed. But you don't have the right to change the document because it's now irrevocable. Are you guys with me? It means we have the control to adjust it as necessary, but our heirs do not. They have the ability to receive it and like it, or as we used to say, or lump it. You get what we say you get. But here's the truth, and this has to do more with our Christian families. I would rather my children be disappointed with me than angry and bitter because the brother stole more, talking with a slick lawyer to a judge because he got money in probate. Look, I'd rather those guys have a decent communication and then be disappointed than to see what someone got away with. And the last thing is liability. Just because I have a trust doesn't mean my daughter couldn't divorce. It doesn't mean my son couldn't drive recklessly and, God forbid, kill somebody with his car. Those things could happen, but if they happen, they will affect their estate, not mine, because we did not commingle. Are you guys there? All right, now what I would like to do, Wayne, if you could help me, is do the commercial and tell you who we are and what we do. And we have some brochures. We've passed out, I think, a good chunk to this group. I don't know. We're going to try to get one to every family. And I don't think we can do every individual. And Wayne, I need one. I just realized I didn't grab one. I might. Yeah, I got a few here. Let me take one and you take the rest of those. For expedience and to go on, I'm going to point out what I'm showing. He's going to bring it around, but I can't do that and talk to everybody at the same time. So for those that don't have one yet, I'm going to show you what you're getting, okay? I'm going to hold it up here. Sorry. But we're getting them to you. But we can't be in everywhere. Wayne, this side too, but I know you're busy. You can only be one guy, right? Thank you. If you guys will be patient, please, but it is coming, I promise you. But for those that have it, take a look. For those that don't, here's what you're going to peek at. If you look on the inside of the brochure, you're going to see a picture of the company president and a welcome letter to you. And in the opening paragraph, it says, since 1996, we have helped over 35,000 clients. A couple of paragraphs down is my name circled, Daniel Leonhardt. And if you go down below his picture, you will see that we do this in multiple states. We also do this not only Virginia, but in Texas and Tennessee, Kentucky, Arizona, and California. Also, let's go to, underneath that is our website, ameristate.com. That's where you can go check us out. Lots of great information there. And then if you go below that, you're going to see the Better Business Bureau. We put their website and phone number. We want you to go check us out. Lots of great information. We have an A+ rating. It tells you that right here. Now, on this page, it talks about understanding estate planning, and it talks about what is an estate, who needs an estate plan, how does a trust work, why would I want one, and you can all read that when you get home. Some of you can't read it at all right now, but it's coming, I swear. The next page, if everybody, those that has one, turns, it says common estate planning strategies. And the first strategy mentioned is the I'll get to it someday strategy, the procrastinator's plan. Well, the do nothing plan eventually becomes the state plan. You don't want that. Then it talks about dying with only a will. And then it talks about having a revocable living trust. Down here it talks about the incapacity documents, the powers of attorney, the advanced directives. And then over here it talks about the perils of probate, why you don't want probate, what triggers a probate. Again, the minimum amount in Virginia is $15,000, so it doesn't take much. And then down here it's the key problems of probate. It's expensive, it takes a long time, there's no privacy, there's no control. A lot of what I'm going to tell you today, folks, is already